May it please the court.
This is case 2011-0732, the State of New Hampshire versus Alan Lathrop.
May it please the court. I'm Joshua Gordon. I represent Alan Lathrop. He's here this afternoon, and he lives in a private lake community in Lake Winnipesaukee. The result the state urges here was explicitly rejected by the legislature. It had the example of Massachusetts before it, which at the time this statute was written prohibited DWI on private roads, whether defined as physical or legal access. It also had several examples which prohibit DWI everywhere within the state. But the New Hampshire legislature chose a more limited scope. A landowner can drive on their driveway in whatever condition they like on their own driveway. And by applying the DWI laws only on roads open for public use or closed to the general public, the legislature gave the landowner authority to determine which private roads the law applies to.
Can I just ask this question, Mr. Gordon?
Sure.
I'm sure that neither side really argued this, but as I read the statute, why isn't this a way, because it was laid out under authority of a statute?
It wasn't laid out under authority of statute.
It wasn't laid out under the, I guess what I'm thinking in terms of a statute is the zoning and planning laws of the community. In other words, if this lake subdivision is laid out pursuant to the zoning laws that apply to, subdivisions, isn't that a statutory layout?
Well, the only facts that are in the record on this are that the development was built around 1970. The specific date wasn't given. I have no idea whether Moultonborough had zoning at that time or what the issues are. I would be happy to have you decide on that issue because the state didn't prove any of that. But it's, I think generally there's something in the record somewhere that says it wasn't laid out pursuant to a statute.
Do mail
How it
delivery,
was laid out, I don't know.
Do mail delivery trucks, UPS, FedEx, access this road?
Yes, they can.
Are they guests?
They're guests.
How can they be guests? I think of guest as someone like you that I say, please come visit me at my house, not necessarily the postman who shows up every day.
Well, the postman won't come to Mr. Lathrop's house for a variety of reasons, but UPS, for instance, might. But they're an invitee.
But a guest and an invitee are not necessarily the same thing.
Well, let's go with guests.
Invitee is a broader category, wouldn't you agree?
The sign says guests.
Yeah.
And you can tell the UPS man, I want my UPS deliveries, at my post office box or at my place of work or wherever. I don't want them here, and the association can do that. So insofar as they allow the UPS truck, then the UPS truck is a guest.
Okay, so I'm lost. It's dark. I don't know where I am. I see the sign. I'm scared. I figure maybe there's somebody down there because it looks like it's probably a nice place who might be able to help me out. I'm not allowed to do that?
Well, by turning onto the road, you are trespassing, but if someone's nice enough to give you directions, then you're a guest.
But I don't become a guest till after I get there.
You don't.
What about the fact that the town plows and the police patrol these private roads?
The town plows by niceness. There's a political will to plow, but no obligation to plow, and that's
But they're afraid they'll get sued if they fail to plow and someone's house burns down.
Well, I think the record says they were afraid it would be a political issue, not a liability issue.
Well, political issues and liability issues sometimes get wrapped up inside of each other. So if the community is happy to have the town use its roads for purposes that suit it, how can it be heard to argue that, well, it's private if we say it's private?
Well, I'm not so sure that if the police fail to respond or something like that, that they would be liable. And that's, under RSA 674-41, that's the statute that provides that if you live on a private Class 6 road, you can waive your right to emergency services.
But those get recorded and signed and recorded, right? Were those done in this instance?
No, there was no waiver in this case, but still, it's not it's not altogether clear whether in a private road that, with the signs like those, that the town has liability.
Let's go trespassing again. Say I drive in there to make a cell phone call, and I'm there for an hour. What, as a practical matter, what's going to happen to me? I'm sitting in my Tiguan, eating a sandwich and talking on the phone.
It depends upon whose house you are parked in front of and how they feel about your parking there, I suppose. If you're Dick Cheney and the Occupy Winnipesaukee Street comes, it might be a lot different than if you're sitting there on a cell phone. But nonetheless, you're a trespass.
In order to find for your client, is it your position that we need to find that it's a driveway, that all the roads in the development are a driveway?
I don't think so, but I think that's a convenient analog. And the issue, I think, is it's very clear that if my driveway is a dirt road, a half-mile long, with just a mailbox out front, that's probably a driveway with or without signs like this. But if I live in an area where there is a shared driveway, where there's 2 or 3 or 4 houses up there, and maybe my driveway, because there's houses, maybe it's still unpaved and small, or maybe it gets bigger and wider and paved.
How far off the, I'm sorry, go ahead.
Those conditions make it. This is an element where you have to prove it beyond a reasonable doubt, and I think the private driveway or the shared driveway is the gray area.
But the police don't patrol that kind of driveway.
No, they don't. And they don't have to patrol this kind of driveway either, and which is why I suggested that the answer to the liability is not nearly so clear.
Does the association reimburse the town for the plowing?
No, they pay for their own maintenance of the roads, but the plowing is paid for by taxes. But there's a case on point, the name of which escapes me now, that says, I think it's Catalano, that says plowing alone is not evidence of maintenance of a road.
That's right. How far down the road was the vehicle when the accident occurred?
My estimate is a quarter mile, half mile. You couldn't see it. It was around a bend. So there's no visual.
I take it that a number of people live on these private roads
Yes.
once you enter Wildwood. My question is, would it not be reasonable for the legislature to look at this situation and say, we have to protect the other residents? In other words, we have DWI laws to protect against terrible accidents. So if in this case your client had an accident that injured someone else who lived on one of these private roads, it strikes me that the logic, the public policy reasons and the logic for the DWI laws have to apply in this situation to protect the other people who live on these private roads.
I think it cuts both ways. On the one hand, yes, that certainly makes some sense. On the other hand, there is a tradition in the state of driving your skidoo around your own property in whatever condition you want to drive it around. And so the legislature chose this middle ground. If a road is open for public use or not closed to the general public, then the DWI laws apply. But if not, then they don't.
But so there's no protection then for the other residents in this development, this private community. There's no protection for
Not so,
them
Your
as
Honor.
against DWI.
I beg to differ. If the association took a vote and changed the signage, they sure could. They could say they could have no sign at all, in which case DWI laws would no doubt apply because this place looks like a...
So they'd have to do it all or nothing. In other words,
No,
in
I
order
think-
to protect themselves against drunk drivers, they'd have to open their roads for public use, so you say.
Well, I think they could make their signs, they could formulate their signs in a way that they like. They could say something like, traffic laws apply here, like some stores do, theft laws apply here, or something like that. They could sign this in such a way that it's clear to a person coming there that all the laws apply there, not, and not that this makes
But
clear
from
that
the
they don't apply.
standpoint of a co-resident here, That's not helpful if a DWI accident causes injury or death.
It's not helpful at all, but this is the sign that this association, in its exercise of the privacy or the level of privacy it wanted, that this association decided to erect. And so this is, that sign clearly indicates that this road is closed to all comers.
But it doesn't
unless I
say,
invite you.
it doesn't say trespassers will be prosecuted, so you would only have a civil trespass, is that correct? Not a
Well, if
criminal.
someone's warned once, then they can have a criminal
Right.
trespass, of course, but as far as the sign goes, that's true.
How many houses? How many houses?
I don't know, and it's not in the record.
Can you just refresh my, was there something in the record about, do the police routinely patrol in here? Do they drive cars through and routinely?
They didn't use the word routinely. They said they do patrol.
Okay, but so they do patrol. So, I mean, in that sense, it's open, it's not only open for plowing in the winter, but also open for police patrol, as, I mean, maybe not routinely, but at least, presumably if they said that, that means that they don't just go there to answer a call.
Correct.
All right.
So while your sign has arguably strong language, it doesn't actually prevent me from driving down the road, or Justice Hicks to make his phone call, or anybody who chooses to ignore it, right?
Well, you're trespassing if you go there.
Maybe.
So if you go there, you know that you're subject to those conditions.
Well, wouldn't you have, as the state suggests, a stronger case if the folks who really didn't want anybody coming down there actually put a gate across their private road?
Well, of course they would, and they can put a gate there, but the statute doesn't say gate, and if the legislature intended gate, they would say gated against public use, not open for public use. And as a separation of powers matter, gates are cumbersome and expensive. I'm not sure this court has the authority to say you have to put up a gate.
But to the extent that there's any ambiguity about this open for public use concept, hasn't it been addressed for the public policy reasons that Justice Conboy stated by the testimony at the legislature and from particularly the Association of Police Chiefs and Chief Russell about why they wanted it? And they wanted it particularly to deal with this type of problem, didn't they?
Right. Well,
So doesn't that address isn't that the answer to the public policy argument you're making?
Well, there's two responses. One is some of that testimony was that someone is being pursued and they turn down a private road in order to avoid detection, and that doesn't that the law just isn't that. If someone's being pursued and they turn public, police can keep on pursuing them. The second issue is that those in those testimony never came up. A road with a sign such as this never came up. And so presumably they were talking about private roads, but not private roads with no trespassing, do not come here, or whatever it says, stop, do not enter, private road. That's not in that testimony. So it's not addressed by the legislative history at all.
So if instead of making a phone call, I needed a safe place to drink in Moultonborough, I could drive right up this road and have a couple of six-packs, right?
Are you an owner?
Why does that make a difference?
Because, you're not invited unless you are.
Well, but it's not, it's whether it's a way or not. Not who the owner is, not the status of the defendant.
Well, it's the landowner who has the rights on the private land. I'm not sure anyone else does.
But if they exercise that, doesn't it become a way? Am I immune from arrest? Don't
Well, I
worry.
don't know.
Don't worry, I'm not going to do it.
I think you're not, because you're not a landowner, and you are not there for you're as uninvited as everybody else.
But that's only if the landowners decide to say, leave, get out of here, or calling a tow truck. Arguably, if nobody either notices or cares, because it's a nice car and he's not making a fuss, he's immune from prosecution on that road.
Well, I think that's only because he successfully found a dark place in the middle of the night, not because it's got nothing to do with his status as an owner.
What about the Tardif case? I have a note to myself, and I'll confess that I don't quite understand my own note, but the state appears to argue that the statute was amended, the way statute was amended, to address so-called ways in trailer parks, which are analogous here.
Which are now. Well, Tardif obviously is dated, and the specific portion of the statute that it addressed has been amended. But the statement that this court made...
So right now,
Yeah.
if you drive on a road in a trailer park, a private trailer park, it's a way for purposes of DWI.
Yes, I think so.
Okay.
What about the
so
roads
why
on
is-
Governor's Island?
Yeah.
I'm sorry.
I'm not familiar with it. Are they private or public? Do they have signs like this? I just don't know.
I'm not going to give you an advisory opinion.
So how is this distinguishable from roads in trailer private trailer parks?
The statute says so. It's not...
The trailer park statute says so.
The trailer parks are no longer governed under the open for public use portion of the statute. They're separate portion of the statute. But Tardif did say that, I'm not sure I can get the language precise, but Tardif said that if you... Tardif said that if a road is common and open to the public, if it's not commonly open to the public or something like that, then it's not public. I can't remember the words, but there is a line there, whether it's dicta or not, it's still a line there that makes clear that if a road is not generally useful to the public, then it's not a public road.
Well, we'll read it, and thank you very much.
Thank you very much.
Case submitted, court is adjourned.